It's kind of weird. I just turned on now. Yeah, it wasn't deliberate, and I don't think I ever actually watched it quite deliberately. But anyway, there's that. Thank you, Agent. I appreciate that. Okay, I turned the attendance on. I lost my little connector thingy, so I'm using the classroom computer until it arrives. Okay, so last day of class. It's hard to believe as the time is here. Your exam is on the 7th. Is that right? Yes. So you're funny. Yeah, but your ConLaw exam's on the 7th, right? And your prior exam is the 4th? All right, so what I'll do, I don't like doing this, but for the cutoffs for questions, it'll be 5 p.m. on Wednesday the 5th, okay? Yeah, so your exam is on the 4th? No, my exam's Friday, but the previous exam's on the 4th? So I'm making the cutoff for questions for me, if you want to email me questions, Wednesday the 5th at 5 p.m. The reason why is I find that as you get closer to the exam, the quality of questions declines precipitously. They're usually born out of panic and absolute disgust and fear. So I would usually make it 72 hours in advance. But I'll make it 48 hours because you have an exam right before. So I'm going to take that consideration. But I usually make it 72 hours. My property kids have 72 hours. If you want to meet during the exam period, email me and maybe we can figure something out. I'll be here on campus during the day on the 4th. But you're probably all studying for your other exams. So you're not going to talk about ConLaw then. So we'll maybe work something out. Okay? All right. Any questions in general? Things on your mind, not about the final exam, but things just generally in your mind. Yes, ma'am.
Is there anything you want to tell us?
You know, I haven't written the exam yet, so I don't know. Quite deliberately, I'm a terrible liar, and I can't keep secrets. I'm really bad, so I actually haven't written any of the questions yet. That comes like later this week, so I have no idea. Other than do as many of the old exams as you can. I repeat myself. I can only ask you the same question so many different ways, but just with different permutations. So the more old exams you do, the easier it will be to spot the issues, because I repeat. And I repeat myself. Anything else generally in your minds? Okay, very good. All right, so my goal for today is to go over question number 2 on last semester's final from May of 2018. I've already gone over with you an old question during the midterm. This was one, the first question was, I really messed with you, it was in the year 1787. The Constitution was just being drafted and ratified. But I want to go over a modern question for you during the thing. So I'll go over question number 2 from the last final. I will go over the hybrid A+ answer, and I'll walk you through the midterm of what exactly I'm looking for. At this point, I think I've met with every one of you, gone over your midterms, so you should have a sense of what you're doing. I encourage you to take as many of the old exams as you can before your exam period starts. Once it starts, you get all scrambled. But be ready for it. Okay? All right, so let me start. So last semester's final was a modern question, and it was based on contemporary debates about sanctuary cities. So to the extent that I ask you a current question in the year 2018, it will probably be something that's going on currently. Now, this is very important. I don't expect you to know anything about current events. That would not be fair, and I mean that sincerely. I will give you all the information you need to know to answer this question, and if you know something, it probably will hurt you because you're probably wrong, right? But I'm going to give you all the information you need to know, so just follow what I give you in the fact pattern. So it says, instructions. The year is 2018. Following the then recent presidential election, the executive branch has increased its enforcement of the immigration laws. In response, California has enacted 2 so-called sanctuary city laws. These federal and state actions have been challenged in the lower courts, and the appeals are now before the Supreme Court of the United States. You're a law clerk for the Chief Justice, and you ask for a memo of no more than 1,000 words. Okay, so a few things jump out. Again, there are 2 parts. Each part is 1,000 words. Not 2,000 words total. 1,000 and 1,000. If you write 800 and 1,200, that doesn't count. I will stop reading 1,000 for question 2. So please do a word count separately for each exam. Okay? Second, very often I will be asking about state and federal laws that may conflict. So please keep in mind whether it's a state law or a federal law, and different laws apply to both. With a state law, they have a general police power, but those state laws are preempted by federal laws. So long as the federal law itself is constitutional. That's one way I can get you, right? If the federal law is unconstitutional, then there's no preemption. So that's a very easy way for me to test if you understand that relationship. Okay. What I suggest you do first is read the prompts. Last year I put them in boxes. I don't know, did you like that? Was that helpful? No? No?
Yes, we like that. Yes.
All right, I'll do it again. Sorry, Kanisha. Sorry. I have to deal with the wisdom of the crowds. I did that so they jump out at you and they stand out a little bit more. I can't really do color because they don't print color exams like with different red ink or whatever. So I think that will help work. What? Okay. All right. So question 1 says, assess the constitutionality of the Boer Act. Okay, that doesn't really give you much. Question 2, who has a stronger argument? Is the United States correct that resist acts unconstitutional? Okay, it doesn't really give you much either. How should the Supreme Court resolve a conflict? Okay. Question 4, how should the court resolve this claim? Okay. And then question 5, okay, your policy. Okay, just what role the 14th and 10th Amendment should play in the conflict between the state and federal governments. Okay. These questions are not very helpful. Sometimes they will, sometimes they're not. You don't know in advance. But sometimes the questions will actually give you a hint of what I'm looking for. But in these cases, the questions are not very directive. Okay, so let's do question number 1. Let me read it to you. Okay. All right, and again, you don't need to know anything about anything. I give you all the information you need to know. So it says, generally, in order to make an arrest, federal and state law enforcement officers must obtain a warrant from a neutral magistrate by demonstrating that there is probable cause to believe that a crime has occurred. Again, I don't care if you're in the 4th Amendment. This is what you need to know. However, there are exceptions. The police can make a warrantless arrest. For example, under the Immigration and Nationality Act, a federal immigration officer can make a warrantless arrest. This is actually from the statute. If he has reason to believe that the alien so arrested is in the United States in violation of any such law and is likely to escape before a warrant can be obtained for his arrest. This is an actual statute that's being litigated now. So this is a real live issue. But my exams are usually very accurate. Not 100% accurate. I change things around a little bit, but they're almost always drawn from actual legal disputes. And I love acronyms. California enacts the Beware Act. Before escape, warrants required for enforcement. Yeah, good. I've got some really good ones over the years. Under this law, a federal immigration officer needs to follow a specific procedure to make a warrantless arrest in California. Arrests made with a warrant are not affected by the Boer Act. First, the officer must apply for a certificate from a California state judge by showing that a specific alien is likely to escape before a warrant can be obtained for his arrest. Second, a state court is required to determine if the alien is in fact likely to escape before a warrant can be obtained for his arrest. If the court does not grant or deny the request within 1 hour, 16 minutes, the certificate is issued automatically. Third, once the officer has a certificate, he can make the warrantless arrest. Now, if an officer attempts to make a warrantless arrest without the certificate, he'll be assessed a civil fine of $1,000. Okay? So let's just understand what's going on here. Federal law says that an agent can make a warrantless arrest on his own determination. He does not need to ask for permission from any state official to do so. The California law says, no. You need to jump through some hoops first before you make a warrantless arrest in our state. You have to go to a judge. You have to show the judge what's your evidence that this person is likely to escape. The judge determines, is your evidence adequate? Maybe it is, maybe it's not. If you try to make the arrest without going to the judge first, this federal official will be fined by the state $1,000. Now, let's say there's exigency, right? There's an emergency. If the court just sits on it for more than an hour, you get your certificate. Okay, so at this point, a couple cases should be screaming very, very loud in your minds. If these cases aren't screaming loud in your minds, you haven't done your studying yet. The first case is Prig. Okay? The facts are actually fairly similar to Prig. In Prig, you had the Fugitive Slave Act, a federal law that authorized people to capture runaway slaves and bring them back down south. Pennsylvania enacted the Personal Liberty Law, which required the slave catcher to go to a state court judge and obtain a certificate to authorize him to extradite the runaway slave. Okay? Was Pennsylvania's law valid? The answer was no, because the court upheld the Fugitive Slave Act as a necessary and proper means of regulating, I don't know exactly what it was, but just necessary and proper, right? Kind of a broad definition. So here, does the federal government have the power to make these arrests over immigration? The answer is probably yeah. So therefore, the state law is imposing additional requirements on the federal officer. The second case that you should be thinking about now is Mcculloch in Maryland, where you had the state of Maryland impose a special tax on the federal bank. And if the federal bank didn't go and get whatever registrations required by the states, you actually impose a fine on the bank manager. And if the bank manager didn't pay that fine, he went to jail. And there the court held that you can't have these state laws interfering with the operation of the federal power, the federal bank. Okay? So there's not only a question of preemption, but also it makes it even more difficult, right? Because the Attorney General says we shouldn't have to decide who's likely to escape. The government says, by definition, any alien is likely to escape without a warrant. So the state court is requiring people to, requiring the feds to put a burden that does not otherwise exist. Okay, so let's take a look at the hybrid A+. Okay, so it says, the Ware Act enacted by California is likely unconstitutional. Okay, good. Put your answer right up front. Is it constitutional? Yes or no? Article 1, Section 8 provides that Congress has the power to establish a uniform rule of naturalization, right? That's what gives Congress power of immigration. Likewise, it allows Congress to make all laws that are necessary and proper for carrying into execution the foregoing powers. Exactly, right? You have to go naturalization plus necessary and proper. Mcculloch v. Maryland, the court determined that Congress can enact legislation as long as its ends are legitimate under the Constitution and it's appropriate and plainly adapted to those ends. The Constitution provides that Congress has the power to make all laws necessary and proper regarding naturalization, and they've chosen to do so through the INA, the Immigration and Nationality Acts. Very good. This act provides a basis for warrantless arrests. In Prig, Justice Story determined that when Congress has the exclusive power to regulate an area within the Constitution, there cannot be concurrent power from within the states to prescribe additional, that's the key word, the additional restrictions for the same purpose. The Ware Act seeks to be precise what Pennsylvania tried to do in Prig. Furthermore, like in Prig, Beware attempts to punish as the officer for carrying out the duty which Congress explicitly permitted. It's unconstitutional. I think that's a pretty thorough answer. I'm pretty sure that got a 10. Mcculloch, Prig, yeah, okay. All right, so I think that's a pretty good answer. I think the memo more or less reflects it. Anyone have a question number 1 on the first question? Anything on your minds? But I want you to take a look at how this person structured the answer, right? Assess the constitutionality, and they lead off right away. Number 1, it's unconstitutional. I like when you take a position and then back it up, right? I don't care if you say yes or no. I think in this case it's fairly obvious it's unconstitutional, but I want you to take a position one way or the other. I think that makes for a much stronger answer. It shows me you're not just trying to guess and throw something on the wall hoping it sticks. You want to give me an actual answer. Okay, any questions on number 1? No? No? Okay, we'll move on to question 2. This is also a live issue in the courts right now. Under federal law, known as Section 1373, I talked to a report about this exact law today. Small world. States may not prohibit or in any way restrict any government entity or official from sending to or receiving from the federal government information regarding the citizenship or immigration status, lawful or unlawful, of any individual. So very often I'll give you a statute that reads like gibberish, right? And you might have to read it a couple times to understand it, which is fine. These are actual statutes. I'm giving you real stuff, so this is as practical as it gets in this class. But just look what's going on. The federal law says states may not prohibit any state official from restricting the sharing of information regarding an immigrant's immigration status. Again, so let's see practically what this means. Federal law says, California, you can't tell your local sheriffs, for example, that they are prohibited from sharing information with the feds, right? It restricts states from restricting information to be shared with the Fed. It's a double restriction, which makes it complicated, right? The feds restrict the states from restricting information shared with the feds. Specifically, what kind of information? Information regarding the citizenship or immigration status, lawful or unlawful, of any individual. Okay? This is a huge provision that's being litigated now in courts across the country. Let's continue. California enacts a second law, resist, requiring every state institution to share tactfully. That's not bad. Under this law, California state prisons are prohibited from sharing with the federal government any information about the release date of an alien in custody. Now, I just want to pause here. This is a real live issue. Does this statute say anything about release dates? No. So here's actually the issue that's being litigated. Very often, the federal government will call a prison saying, you have a person in your custody. This person is not in the country lawfully. We want to detain them. Please tell us when you're releasing this person. And the state prisons say, screw off, we're not going to help you. This is litigated across the country. So the feds say, aha, under 1373, you're required to disclose to us the person's immigration status. And they say, okay, fine. Here's his immigration status. Not here legally. We've done our job. So the problem with the statute is it's very poorly drafted. It doesn't do what they think it does, right? It doesn't actually speak to the question of whether the prison must give the date and time and location of the release of a given inmate, right? Just reading the text, and this is what drives me bonkers. The statute's very, it doesn't do what you think it does, right? But California, in this case, went further, right? So as a consequence now, the feds will say, we can't pick people up at the jail, okay? The Resist Act prevents federal agents from taking custody of a suspect at secure facilities, reducing the likelihood that the suspects will be caught and puts officers in danger. So as a policy matter, this is probably, not the best idea, right? Because now they have to arrest a person in a home where there might be children, there might be resistance. It's much safer to do it in a prison, but can the states be made to do this? Okay? So the Attorney General of the United States demands that the California AG disclose a date on which an alien in the state's custody will be released. Citing the Resist Act, the AG says, screw off, no. The federal government challenges the Resist Act, and then they counterclaim saying that the Section 1373 is unconstitutional. So we have a conflict here, right? If Section 1373 is constitutional, then it preempts the state law. But if 1373 is unconstitutional, the state law is fine. So you have to balance, right? Is the state law constitutional or is the federal law constitutional? This implicates the commandeering doctrine, but in a slightly different way. It's not making the states enact a law like in New York versus the United States. It's not forcing the law to, it's not forcing the state to take any action, such as, running a background check. It's asking them to share information within their custody, right? Does forcing them to share the information violate the commandeering doctrine? Probably, but I think the answer is complicated. So I can go either way on this one. I'd accept the answer yes or no. Okay? But here's the key. How do we understand the necessary and I'm sorry, damn it. How do we understand the commandeering doctrine? It's an application of necessary and proper, right? Is this a law that's necessary to the federal immigration power? Probably. Is it proper in the sense that it intrudes into state sovereignty, telling states what to do? I don't think so, but I can go either way. So what I want you to see is actually going through the necessary and proper doctrine correctly, right? Don't just say, oh, commandeering 10th Amendment, I'm done. That will not get you full credit. All right, so let's take a look at the hybrid answer. Question number 2. California is probably correct that Section 1373 is unconstitutional. Good. Put up front your answer. This is a 10th Amendment dual sovereignty issue. In this case, 1373 is federal legislation that attempts to control state officials. More specifically, the AG is required to disclose the date on which an alien in the state's custody will be released. This is a clear violation of the commandeering principle laid out in New York and Prince. I don't think it's clear, but I do think it's a violation. In short, the case purports that Congress may not commandeer the legislative process of the state by directly compelling them to enact and enforce a federal regulatory program. In fact, as Scalia mentioned in Prince, the structure of the Constitution confers upon Congress the authority to regulate individuals, not the states. Since the U.S. Attorney General is compelling the California AG, an executive official, to adopt their federal program, this violates the commandeering principle. Furthermore, resist is constitutional because the states are allowed to direct individuals within the state to not comply with federal officials. This goes back to Prig, where individuals are free to disobey orders from the federal government about the whereabouts of runaway slaves. This is very good. If you remember in Prig, the court held that they can command state judges to comply with the Fugitive Slave Act, but they cannot compel private individuals and executive branch officials to comply with the Slave Act. So I think this is a very good answer. I like the way they ended it. So this, I think, is a fairly thorough answer. Anything on the memo missing? New York, Prince. Yeah, Mcculloch, Prig. Yep, got everything. Okay. Questions number 2. Yes, Mai?
So whenever we talk about the commandeering doctrine and a necessary and proper, I'm trying to go back to Article 1, Section 8 and find out which clause
Yes, ma'am.
that the necessary and proper
Exactly.
to help. Is that the one about the Congress has the power to make rules, establish rule of naturalization?
Yes, ma'am.
Okay.
Yeah, with immigration, it's actually a fun question I've written about recently. What federal power gives Congress the ability to regulate immigration? It's a much tougher question than you think, because naturalization means the grant of citizenship. It doesn't refer to all aspects of immigration law. There's not a very good answer to this question. The best answer I come up with is a very broad necessary and proper. But there's no clear federal power over immigrants already in the United States. In fact, in the early years of the Republic, the states regulated immigration. I'm not sure if you'd like that answer much better if the states could regulate immigration, but that's where we are today. Okay, any other questions at number 2? Questions at number 2?
What about Barron?
Oh yeah, go ahead.
Barron v. City of Baltimore. How
Okay.
would that case be applicable in terms of state sovereignty?
Well, I mean, Barron's no longer good law. Right. Well, but why is Barron no longer good law?
I'm not sure
Well, what did Barron hold?
that the state, oh, well, that's the one where they held for the state. And then isn't that where there was like unrest and, is that the case where it almost caused like a war?
Not Barron. What case are you thinking of?
Um,
Barron was whether the Bill of Rights applies to the states, right? Whether Maryland was required to pay for a taking of property. And Marshall held that they're not. Barron was reversed by the 14th Amendment.
I have the wrong case.
Which case are you thinking of? Legal tender, maybe?
No, it was the case where the Supreme Court, this was very early on, and the Supreme Court held for the state. And I guess I'm getting it confused, but they held for the state, and then it just caused like, it was in the very beginning.
Chisholm?
Maybe.
Think about it and come back to me later if you think of it, okay? I'm not sure what you're thinking of. Now it's going to kill me what you're thinking of. I don't know. If anyone knows what you're thinking of, you can raise your hand. I'm not sure. Yeah.
I think it's Chisholm. It was the 11th Amendment that came right after that.
Right.
It was the state sovereignty. Yeah.
Okay, yeah. Okay, Chisholm. Okay, good guess. Thank you. Thank you, Sergio. Okay. All right. Any other question? Any other questions on number 2? Okay. Let's do question number 3. Making good progress. Moving along very nicely. Okay. Okay. This is a spending clause case. In 2006, Congress enacted a statute. What happened?
Oh no, I'm in my head. I'm like, I don't remember the cases.
Good. In 2006, Congress enacts a statute that allows states to apply for financial grants from the federal government to support law enforcement. Under the statute, states that submit application for grants must comply with all applicable federal laws. Now, I just want to pause you right there, right? There are a lot of federal laws. There are so many federal laws, we can't count them. There have been efforts by experts to count the number of federal criminal laws in particular. You can't. There are too many. It's impossible to count because there are a lot of these regulatory crimes. It's nuts. So one of the aspects of the spending clause doctrines are the conditions clear, right? Do you know what's being expected of you? And one of the problems here is, what the hell that means. All federal laws, right? Even before the enactment of the Resist Act, California did not comply with Section 1373. Okay, it says, over the past decade, California has received roughly $5 million a year, a minuscule portion of its budget. It was used to purchase new vehicles for local law enforcement agencies. In 2018, the United States Attorney General issued a new opinion. In order to be eligible to receive these grants, states must, quote, comply with all applicable federal laws, including Section 1373. Okay? So did that action pose a new condition? Right? One of the issues with the Obamacare cases was this a new condition or conditions already in existence? Well, on the one hand, if they had to, if they had to comply with all federal laws, okay, then there's nothing new. On the other hand, if they were never complying with 1373, then maybe there is something new. Okay, let's keep going. Because the Resist Act prohibits Congress from sharing the release dates for aliens in custody, the AG concluded that the states not complying with Section 1373. Can the Attorney General add new conditions to spending grants? Or can only Congress do that? Right? We've only done cases where Congress adds spending conditions. Can the AG do that unilaterally? Okay. As a result, the AG denies California's request for a federal grant in 2019, even though the state meets all the requirements to receive the funding. The California AG challenges the constitutionality of the denial of the federal grant, arguing that the new condition, compliance with Section 1373, has nothing to do with law enforcement grants to purchase new police vehicles. This is what's called the germaneness or relatedness aspect of the Dole decision, right? That the spending condition must have some relation to what the money's being spent on. The United States government says that the Congress gave him the authority to deny the grant, discretion. So question 3 is, how should the Supreme Court resolve this conflict? Can the AG deny California's request for the grant? Okay, let's go with the hybrid answer. Question 3. The AG might have discretion appointed to him by Congress, but cannot include the stipulation of adhering to Section 1373. This does not adhere to the facts necessary in the conveyance of money to states in exchange for certain stipulations. It's a little cloudy language, but I think you know what you're getting at. South Dakota v. Dole provides factors for giving states money with conditions. The grant has to be for the general welfare. The stipulations have to be unambiguous. States must be aware of the decision agreement, cannot be an open-ended promise. The conditions on a federal grant have to be a connection between the money being spent and what the federal government wants to accomplish. And federal government can't give money with the consideration as barred by another part of the Constitution. Again, I don't like listing the 4 factors. I think it's a waste of space. I would just focus on the ones that are maybe not satisfied. They run afoul, oive. That's how you spell afoul. Happy Thanksgiving, everyone. That's not afoul, right? It's afoul, right? Of the 3rd factor. That I think is right. I think there's the failure of germaneness, relatedness between the condition and the money being spent, right? The money was not being spent, anything related to Section 1373. There's not close enough fit, right? I think I discussed this in the memo. There are other factors that are worth discussing. This was not the best answer. So yeah, there's germaneness, the relatedness, right? Even though it's a small portion, right, it's not coercive under the Sebelius decision, okay? The other one is, can the AG add conditions, or only can the Congress do it? This actually raises delegation issues, right? Can Congress delegate the power of the purse to the executive branch without any conditions? I think also you have a void for vagueness issue because there's not clear conditions on what those federal laws are. So there's a lot of things you can write about. And again, this was a 10 or probably a 9, and I didn't even like it very much. So you see I can do well without even getting everything correct.
You said only list the factors that...
Yeah, I think spending 4 lines listing the 4 factors is not a good use of space.
So just the ones that...
Yeah. I mean, and the reason why is this, right? Anyone with a commercial outline can list the 4 factors. That doesn't really tell me anything that you know it, right? I don't think it's a worthwhile use of like 4 sentences a lot of time. I mean, he mentions them and never comes back to it, so doesn't do anything for me, right? I want you to give me stuff that's not in your outline. That's why I think the exams are valuable. If you're just copying from your outline, there's not much impression. Okay, so questions at number 3.
Sarah,
Yes, Maya?
just to locate their Congress delegating the power of the purse to the executive branch, is that under Schechter's? Yes.
It's a foul, yeah. Oh, God. Happy Thanksgiving, everyone. Sorry, I couldn't help it. Couldn't help it. How many chicken jokes can I make today? Hopefully no more. More? You want more? Fine. I'll stop. All right. Anything else on number 3? Nothing? All right, I'll move on. Go to number 4. I'm sorry, yes, Brooke.
Is it non-delegation doctrine or delegation?
Non-delegation doctrine.
So Josh, so for like the way you have the Sebelius case, just saying like under NFIB.
Yeah, the amount itself is not coercive, right?
Right. I mean, I get, so there's no need for any further explanation, just citing the case, that's just it.
That's good, yeah.
Okay.
Yeah, you can say under Sebelius, because it's a small amount, it's not a coercive grant, a withdrawal.
Okay.
Yeah.
Okay.
And specifically because I mentioned the facts, a minuscule portion of the budget, right? I wouldn't put that in the facts unless I want you to write about that, right?
No, I was just,
Yeah.
I didn't know if you want like more explanation as to,
Okay.
more of how it's applicable.
Yeah. No, that's good.
Okay, so just.
Yep.
Okay.
Yeah. All right. Number 4? All right, so number 4. In 2012, the Obama administration announced a policy known as DACA, Deferred Action for Childhood Arrivals, that will grant lawful presence and work authorization to certain young immigrants. Over the past 6 years, nearly 1 million aliens, 80% of whom are of Mexican origin, were granted status under DACA. In 2018, President Trump issued an executive order instructing the Homeland Security Secretary to terminate DACA. President Trump concluded that he's going to have the statutory or constitutional authority to grant lawful presence and work authorization to the DACA recipients. He also determined that the limited federal immigration resources should be focused on other priorities. Pursuant to that order, the Secretary moved to terminate DACA. I remember having difficulty writing this question. The California AG filed suit against President Trump and the Secretary of Homeland Security. He argued that the termination of DACA violates the Due Process Clause of the Fifth Amendment because of what he referred to as President Trump's, quote, long history of disparaging Mexicans who comprise the vast majority of DACA grantees. This is an actual quote from the AG's brief. I took this one verbatim. To support this claim, the complaint cited a number of statements made by then-candidate Trump about Mexican immigrants. For example, he said, we have some bad hombres here, and we're going to get them out. I had to figure which line to use, and that was the least bad I could think of, but there are a lot of them. Yes. The complaint does not cite any statements made after the inauguration. I did it deliberately to limit the scope of evidence. There are no allegations that the Secretary made any disparaging comments about Mexicans. Okay. How should the court resolve this claim? And note, he did not challenge whether he has the authority to terminate DACA. A lot of students did that, and that's not what I was looking for. All I'm asking about is the Fifth Amendment. Now, we know the Fifth Amendment has no equal protection clause, but it has a due process clause. And in Bowling against Sharp, the court understood that the due process clause reverse incorporates an equal protection clause. So this brings into play all of our equal protection cases, right? From Korematsu, Yik-Wo, Brown, Loving, Bakke and Grutter and Gratz and Fisher, right? The entire corpus of cases. And here we have comments that ostensibly are making classifications on the basis of nationality, which is very similar to race, right? Which is given strict scrutiny. Okay, so let's see what our friend over here did. Number 4. Okay. The court must look at the equal protection due process clauses afforded in the 14th Amendment. Yeah, it's really not exactly 14th, but in regard to the law regarding race, there must be strict level of scrutiny applied. Under the Equal Protection Clause, Amendment 14, race classifications are suspect, then must fall under strict scrutiny, established in Korematsu. The governmental policy, the means, is narrowly tailored to serve a compelling governmental interest. The ends. I don't think that's accurate here. I'm not sure exactly. That's just sort of just a blah statement from your notes. You're just regurgitating. It's not really saying anything useful. The burdens on the government to prove that the means fit the ends of their policy. Okay, the court may look to Bowling v. Sharp, where substance due process is applied to cases based on race, kind of. We must look to see if the means fit the ends here. And having a law that compromises the education upbringing of many DACA recipients, this would affect the economy greatly. It's like a weird Commerce Clause argument. Not very good. Again, this was like a 9 or a 10, so if you think this is crap, just wait till you see the 5s and 6s, right? It's true. Whenever I be like, wow, these are bad, but I'm grading them, like, wow, these are great. Brown v. Board may be addressed here, and it's important in the context of education. That's good. Children are mostly younger in school. They have a positive, lasting impression. Doll test, just throw that out there. This person probably got an A+ in my class for mocking him or her. I don't know who it was. I forgot. If the country in a whole and younger generation witnesses segregation, an assumption of inferiority with the Mexican immigrants. Okay. Not the best answer. Let's put it in my memo. Okay. Equal protection, right? You reverse incorporate the Fifth Amendment. Racial classifications, like nationality, are subject to strict scrutiny. Does the DACA rescission narrowly tailored to serve a compelling governmental interest? Here, the President states the rescission is necessary because he lacks a statutory and constitutional authority to take such action. He states that he'd rather focus his priorities elsewhere. Are these the real reasons, or are these pretexts? How do we consider campaign statements as before the inauguration? Do they demonstrate animus? Think of Romer and other cases like that, right? Can courts even consider campaign statements from before the inauguration? You have a lot of cases. Yik-Wo, Brown, Bowling, Loving, Bakke, Grutter, Gratz, Fisher. Some people talk about Lochner. I don't know why, but it wasn't really relevant in the economy. I didn't quite get that. Some people talk about Youngstown, where he has the authority to stop it. That just wasn't even in the ballpark. So if I caution you one thing, don't talk about Justice Jackson unless it's actually relevant, right? Far too many students, if they have nothing to say Jackson this and Jackson zone this, it's almost certainly not relevant, right? You only talk about it if the executive is taking action and there's a question of whether he has a statutory authority to do so. If that's not the case, I don't want to hear about Youngstown. It's not relevant. 10 of you will do it anyway. Doesn't matter. Every year. You cite Youngstown when it's not relevant. I warned you. Okay. Questions on question 4? Yes, Mai.
Knowing Trump v. Hawaii now.
Exactly. Yeah, Trump had not been decided yet.
Yes.
That would be a very good question to discuss here.
But then my lump, because I know Trump v. Hawaii is like, what are these immigrants? Are they citizens? Are they not citizens?
Well, okay. So actually, I think Kanisha asked me the same question in office hours a bit before, right? Same exact question, right? Here's the issue, right? Trump against Hawaii concerned people seeking entry to the United States, right, who are not within our borders. And the court held that they are not subject to the usual equal protection doctrine. In contrast, DACA recipients are in the United States and are subject to equal protection. So I think there's a different analysis of those seeking entry to the United States versus those who are already here, which is why I think Romer might be a better example of the animus type precedent that you might have. Maybe even a Bergefell could be cited. I don't know. I think probably bring that in there as well. But maybe Windsor would be the best example, where you had DOMA enacted for moral disapproval of the of gay and lesbian relationship. That might be a good example to cite. But yeah, all the equal protection cases are fair game. But I think Trump against Hawaii is a good example, but not exactly. But it does talk about animus, in the dissent at least. Yeah, Trump hadn't been decided when I gave this final. I mean, the date was, I guess, April of May of 2018, whatever the date was. Mia?
So, should we talk at all, like on a question like this, or would it go too far afield about, like, the executive's duty also to, like, their power and also duty to see if things are unconstitutional?
I think not, because I said don't talk about whether he has authority to terminate DACA. I explicitly said not to do that, and a lot of people did it anyway last year, as I recall.
So we're
just Fifth Amendment, all I want to hear. On question number 4, all I want to hear is about the Fifth Amendment due process clause.
Okay, thank you.
Yeah. Yeah, and just be careful to answer the question I ask, because, look, you can impress me and wow me, but if you're responding to a question I didn't ask, I can't give you points. I can't give you points for answering a question I didn't ask. I think that's fair. And you waste time and space, and I can't reward you for it. If you want to come talk to me afterwards about it, good. God bless you, but not in the exam. Okay. Anything else on question number 4? Moving along pretty quickly. Okay. All right, let's move on. Last question to the exam. Okay. During the Obama administration, states that supported more restrictive immigration policies like Arizona, typo there, sorry, tried to supplement the federal government's immigration enforcement priorities. This was the, if you remember, the SB 1070 Show Your Papers law from a couple years ago, where Arizona tried to actually help the feds enforce immigration laws, and the feds said, you're not helping us, you're thwarting us. During the Trump administration, states that support more open immigration policies, like California, have tried to frustrate the federal government's enforcement priorities. Nothing is new. Everything's been done before. Prior to the Civil War, abolitionist states sought to resist federal slavery laws. That's Prig, right? And after the Civil War, segregationist states sought to resist federal Reconstruction measures. We talked about that with the Jim Crow laws and Strouder and cases of that nature, right? Discuss what role the 10th and 14th Amendments should play in this perpetual conflict between state and federal government. So the policy questions are designed to sweep across the board. What do I mean by that? There are certain themes which repeat class after class after class in different contexts and different clauses. And your job with the policy questions is to synthesize the various cases that center around a single theme. And the cases may not have a lot in common otherwise, other than that theme. So let's see what our hybrid A+ person wrote for here. Whoa, it's long. Okay. The 10th Amendment plays an important role in the conflict between the state and the federal governments because it deals with states' rights and pushes the state police power. I don't know what pushes mean there. Pursues, maybe? I don't know. California wants to maintain their police powers, be able to regulate how they deal with immigrants, aliens. For instance, in Prince, the court held that commandeering individuals is for the states and not for the federal government. Good. The court found that Congress would commandeer state officials to run background checks. Congress was trying to commandeer state legislation, was prohibited. Dole. Not really dole. Dole's about spending. Like in our case, the federal government is trying to make state legislatures comply, but states such as California are arguing the decision for the states. Okay, it's a lot of repetition, not very good. Very repetitive. My standards are high, as you can tell. Additionally, the 14th Amendment plays an important role in the conflict between the state and the federal government. So you have Section 5 of the 14th Amendment, very good. Congress can compel states, but not individuals. States, blah, blah, blah. This is not a very good answer. I don't like it. And again, it's probably one of the better ones. So, you know, don't knock until you try grading 80 of these in a weekend, right? It usually takes me, your class is smaller. It should take me less time to grade. But last semester I had 160 students. This semester I only have 100. Yeah, the essay is just do 160 times 1,000 words, 2,000 words. Just, you can do that math. It's a lot of words. Okay. So let's look at my answer. There is truly nothing new under the sun. Efforts by California to resist the Trump administration, taking a page from the abolition states to resist the Fugitive Slave Act, and as did Arizona to the Obama presidency. Okay. The final question asks you to say the role played by the 10th and 14th Amendments. First, the 10th Amendment does not by itself confer any power on the states or throw any powers from government. It merely states a rule of construction. If Congress lacks a power, then it belongs to the state and the people, generally. The 10th Amendment recognizes that where Congress lacks enumerated powers, the state has authority. But the 14th Amendment flips that presumption, somewhat. Under Section 5, Congress can now enact appropriate legislation to ensure that states are protecting the rights of their people. Also talk about the Supremacy Clause, under which federal law trumps an inconsistent state law. Right, and there are a wide range of cases you can talk about here with federalism. You can talk about Mcculloch, you can talk about Prig, you can talk about Dole, Prince, New York, Obamacare, NFIB. I mean, they're just a wide, basically the first half of the semester, you can probably talk about almost any case that fits in here. Bernie v. Flores with the 14th Amendment, Hibbs, United States versus Morrison, the VAWA case, right? There are so many cases you can bring in. Just go down your syllabus, just check them off. Yeah, exactly. This person didn't cite any, and it was the A, so what the hell do I know? It's always frustrates me because I'm always so proud of people get the A+, and they do this the following semester, like, wow, what was I thinking? And it's not that this is a bad paper, just in the context when you're under the gun, your answers aren't always good as they would be if you have, all the time to reflect on it and people laughing at you and, making all these jokes. I can't remember who this paper was. I have no idea. Okay. Questions on number 5. Oh, yes, Maya.
Yes, sir. Just asking about your grading system. So number 1.
Apparently it sucks, right? Apparently I'm too generous, right? No one should get a 10 ever.
It's going to be a fair question.
Yeah. Yeah. I mean, here, I'll explain it to you, right? So every question is graded on a scale of 1 to 10. If you leave it blank, you get 0, right? If you do it perfectly or relatively perfectly, you get 10. I don't give many 10s, right? If I give on a single question in a class of 50, 1 or 2 10s, that's a lot. I try and reserve that for the very top of the top. If you generally get an answer in the ballpark, I'll usually give you, 5 or 6 points, right? If you can give an answer with the correct rules, 6 or 7 points, right? If you can give me an answer with the correct rules and cases that are on point, 7 or 8 points, right? If you give me the correct rule, the correct cases, and you're actually applying in a faithful fashion, you get 8 or 9 or maybe 10 points. That's the general breakdown. I can't give it to you with any science. I've tried. It varies question by question. But what makes me happy in my own sort of way is the numbers average out the same on every exam I've ever given, where the A+ is usually a 43 or 44, an A is usually somewhere around a 39 or 40, A B is usually a 36 or a 37. A C is usually a 30 or 31, 32. No matter what class I give, without even doing a curve, they fall in the exact same ranges. So I don't have to even try to curve it. To actually get the curve, I do very little work. The curve is almost completely natural. It's remarkable. I've never given higher than a 44 or 45 for an A+. It just never happened. I've never had a 50. I think maybe once I had a 47 in property, but I don't think I ever had one in ConLaw that high. So naturally, you all distribute where you're supposed to be. That's how it shakes out. I couldn't plan if I wanted to.
Follow-up question,
Please.
sir. So is there any incentive to cite more cases than we need to?
Well, I mean, so here's the catch, right? Occasionally I'll get an exam where someone will just dump their syllabus and cite every case that's completely irrelevant, and I don't give points for that, right? If these cases are actually relevant, then I'll reward you. But if you just list check cases, then I'm going to say this person has no idea what the hell they're doing, right? And I'll make the point a little bit more finely. It's not just listing cases that get you there. It's explaining why the case is relevant with at least some analysis. Again, I'm not going to reward you for regurgitating your syllabus. That will not get you points. I know people try it. I see it every semester. Like, wow, they just went to class 7 and copied every case in the list from class 7. I see what they did there in the exact order they're listed in the syllabus, right? So don't do that. I'm not going to, I know what you're doing. But engage the cases. You have to know, by the time you walk into the exam, if I say, Hibbs, you should give me a one-sentence description from memory of what Hibbs is. If I say, Commerce Clause in the Progressive era, you should know, okay, you have E.C. Knight and you have Champion v. Ames, right? You need to be fluent backwards and forwards without even looking at your outline. If you're looking at your outline during the exam, you're probably not going to finish, right? Don't bring to the exam room like binders and binders. You're gonna mess yourself up. You're gonna try flip, and you're gonna run out of time. It's a lot, I know. I don't have an apology. This is how the course works. I apologize for nothing, actually. This is important stuff. You could forget the elements of various torts, but you're not gonna forget this stuff. This stuff will actually stay with you for life in meaningful ways. I mean that sincerely. If I took a contract exam, I'd probably flunk it. I don't remember any of that stuff, but this stuff you need to know. All right. So questions on number 5 or anything in general? Anything on the midterm or the final? Questions, anything else? Anything else? No? Good luck. Thank you all very much. Have a good Thanksgiving. Thank you. Thank you. Thank you. Thank you. Thank you.
I have a question, and it's not in the course. It's just something